The third case on this morning's docket, case number 117305, State of Kansas v. Stephen W. Edwards.
May it please the court, my name is Jennifer Roth and I appear on behalf of Stephen Edwards, and I would like to reserve 3 minutes of rebuttal time, please.
3 minutes is granted.
By way of introduction, this case involves a motion to withdraw a plea. Back in October of 2014, Mr. and Mrs. Moreno Lopez were killed in Wichita. 4 days later, Mr. Edwards was taken into custody, and about a month later, the state charged him with capital murder, or in the alternative, 2 counts of premeditated first-degree murder and some other charges as well. Mr. Edwards was immediately appointed counsel that is capital qualified. A number of months, to be specific, almost a year went by between his first appearance and the time that he asked to have his attorneys fired. Mr. Edwards had not been in court. But anyway, so he asked his attorneys to be fired. The court denied that. Later, several months more go by, and Mr. Edwards eventually enters a plea to felony murder, 2 counts of felony murder. He asked to withdraw that plea 17 days later. The court had a hearing on that motion and denied the same. So that is what we're here. Mr. Edwards' argument is that he had good cause to withdraw his pre-sentencing pleas. So
if we agree with you and say that it was erroneous denial, then we send back and your client can be subject to the death penalty then?
He can be charged with capital murder again, and he was asked that at his plea withdrawal hearing, and I think he was even asked that prior to that, but it's in the record that his counsel asked him that at his plea withdrawal hearing. So it really does boil down, to use the district court's words when ruling on the motion to withdraw Mr. Edwards' plea, it really does boil down to whether or not Mr. Edwards felt coerced into taking a plea because he felt beaten down by his attorneys. Those are the words that the district court used. The court recognized that it had significant discretion in this matter, and it is our argument that the court abused that discretion by making errors of fact and law. We think those errors include the following. The court said, well, he could have told me during his plea hearing that he was being pressured. He had time to tell me that. When I guess, and this is covered in my brief, but there's some other context that happens, as we know, before Mr. Edwards gets to his plea withdrawal hearing. And that context is what had happened in October before, when he tried to tell the court that he wanted different lawyers because all these lawyers wanted him to do was plead. That's all they wanted him to do. And that was the context. So it's not like this is the first time Mr. Edwards had talked about not wanting to plead. And so the court said, well, he had these opportunities to tell me if he was being pressured. Our point is, he already tried that. Mr. Edwards had already tried to tell the court months before how he felt, to no avail. He was trying to tell the court that day how he felt, to no avail. It's even back at the motion to have his attorneys fired, Mr. Edwards asked the court, well, if I file this motion to represent myself, what's going to happen? And the court said, well, we'll hear it. And then Mr. Edwards was like, yeah, and then nothing's going to happen. It's almost foreshadowing, because the point is that Mr. Edwards had tried to tell the court numerous times in numerous ways how he felt. And so by the time he got to his plea hearing, and on the day of his plea hearing, he even mentioned to the court how my attorneys are okay. They actually had to take a break in the middle of Mr. Edwards' plea hearing so he could talk to his attorneys further. So The point is that Mr. Edwards had tried to tell the court this before to no avail. And so as he even testified at his own hearing, nothing different was going to happen. So I didn't tell the court again. In addition, and this is, the court can ask all the right questions and even get the right answers, and you can still have coercion. And in fact, if you were being coerced, one would imagine that you would answer the questions that you weren't.
Let's assume that's true. How do you get at that when you come around to the new hearing?
I'm sorry?
Let's assume that you can get all the right answers during the colloquy, okay? So then you've got a motion to withdraw, you have a hearing on that. What is so it would seem to put on the defendant the obligation to come forward during that hearing with something that explains why I gave all the right answers to all the right questions, and still you should let me withdraw and be subject to the death penalty.
Well, when he was at that hearing, when he testified, he was explaining, I wasn't going to say anything.
At the plea withdrawal hearing?
Right,
Okay.
at the plea withdrawal hearing. I believe his exact words were, I'd already told the judge, and I just didn't think it was going to be any different. I'm trying to remember his exact words. But even at his plea withdrawal hearing, he explained that it wasn't going to make any difference, and so he just stopped telling the judge.
At that plea withdrawal hearing,
That's when he testified about.
right.
Right.
Am I correct that either most or all of the evidence presented at the plea withdrawal hearing in favor of good cause came from the defendant's own testimony?
Yes.
And
but
so what do we do with the fact that the district court made a credibility finding that that testimony was not credible? How do we weigh that in our analysis?
Well, I don't think that I do not take it that the district court found that Mr. Edwards wasn't credible, period. He certainly discounted some of his testimony about
He
what
found
happened between him and Mr. Rudy.
At least one of the major
Right.
allegations being made was found to
Right.
be not credible.
Right. But the court, when I went back and read it again and again, the court did not actually seem to disagree that Mr. Edwards was in fact repeatedly pressured by his attorney. The court specifically talks about the mom coming to visit, but not about the pressure put on him by his lawyers. And the other thing I wanted to mention was, even if you look beyond my client's testimony, his own attorney's testimony supports that this was our goal. We were not going to let this kid have a trial. And so that's the other thing, is that I hesitate to say that most of the evidence came from my client.
Is there anything in the record that supports what you just said, that the lawyers testified we were not going to let this kid have a trial? Because
no.
my understanding of the record was that
No.
they testified the decision to go to trial was always the client's, and they always told him it was his decision.
That's what they told him. And what Mr. Edwards' perspective is the one that is important. And what the evidence showed is that 50 times before they even entered into plea negotiations, the trial lawyers told Mr. Edwards every time the seriousness of this and what was happening and that sort of thing. And so from Mr. Edwards' perspective, every time his lawyer meets with him and talks to him about what's going to happen if you go to trial.
Isn't that an obligation of death penalty counsel in particular, to inform their client and make certain the client's fully aware?
Right. It is, but it goes beyond, and this is another thing that the district court, even as early as the motion to fire his attorney's hearing, arguably sort of, I hate to say mischaracterized what Mr. Edwards was what his feelings would be. But the fact is, what the court, if we see it as this obligation, but we do not have to hear it 50 plus times. And so the message that Mr. Edwards is receiving and is trying to tell the court is, all they want me to do is plea so that this does not happen to me. But I wanted my trial. And so we see that, and it is an obligation. But I think we also have to realize how it is being received by the person who is charged. And that is the person's perspective, that he's the one that we're arguing was coerced. And in fact,
So when you're frank with your client about the strengths and weaknesses of your case, which happens all the time, and I'm assuming that this must have had fairly strong evidence if there's 60 times they discuss the case and say this is what you ought to do. The attorneys are assessing the case, evaluating the case, the strengths and weaknesses, and come to this conclusion. Isn't that what happens all the time in representation? And regardless of how Mr. Edwards perceives what's happening, isn't that the reality of what a defense attorney has to do, or any attorney has to do?
well, as you personally know, I did not death work, but I used to stand next to people for 13 years.
I'm thinking of that,
Right.
the very nature of what you did.
Right.
If you have a case that's just flat out, here's the evidence, you're going to most likely be convicted if it goes to trial, here's what we can do. Isn't that what doesn't that happen all the time, every day?
It does. But what I'm trying to say is that, well, let me bring up a new piece of another part to go with this question. All right, you're right. That is my obligation. But it is also my obligation to, if this person is telling me they want to have a trial or they don't want to have a plea, then in theory, I should be also preparing in case we have this trial. And the fact is that what Mr. Edwards knows, and what is undisputed in the record, is that his counsel never filed a substantial motion, a substantive motion, ever. So when he goes to ask his lawyers to get fired, they haven't filed any motions about the evidence or if there was a statement or no substantive motions. When he goes to his plea, his attorneys haven't filed any substantive motions. And so you're right, that is what we do. But at the same time, there are these other things that are going on that the attorneys themselves are saying, that they're writing to the state, that they are, the message that Mr. Edwards is getting is, we are not going to trial. It's your right to have a trial, but we haven't filed any substantive motions, and we've been, working on you for months to get authorization for us to negotiate for you. And that's the other thing. When you talk to somebody 50 times before you even negotiate, there's a reason you're talking to them. It's because you have to have authorization to negotiate. And so whether you say the words, I'm telling you all this so you'll give me a right, the ability to go ask for you to get a plea agreement, that's what you're doing. You are trying to convince them to let you plead them or to seek an agreement for them. And I think that's part of the message that's being received here.
Wasn't there some evidence, though, that the attorneys had made the professional judgment that this was a mitigation case and that they were preparing a mitigation?
Right, and that's, they have to do a lot of things at once. I have never been in their shoes. And so that's true. They are preparing, they have to do that at the same time. They can't wait. So they're talking to their client about trying to, negotiate, get the permission to negotiate. They're trying to do their mitigation. But when I talk about the substantive motions and things like that, to me that's part of this picture of what Mr. Edwards is seeing, which is, I'm not going to have a trial. I'm not going to get a trial. I don't have a choice but to plead. And I feel like that didn't really answer your question, but I understand that they have multiple things going on at once. But I'm just saying that there are things beyond what my client says that support why he would feel pressure to take this plea. So, I see I'm out of time, so I will
Do we
sit
have
down.
any further questions? Thank you, counsel.
May it please the court, Assistant District Attorney Leslie Isherwood appearing on behalf of the state. We will confine our arguments today to the first issue that was briefed and submit the second and third issues on our brief. The defendant pleaded guilty in this case to 2 counts of felony murder that were amended down from capital murder, as well as aggravated burglary and aggravated robbery. And as has been noted prior to sentencing, he filed a motion to withdraw that plea. And following an extensive evidentiary hearing that was conducted before the same court that accepted his plea, the court declined to grant the relief requested. This
Go ahead.
This court reviews that decision for an abuse of discretion.
Just for the timeline, he's charged with capital murder. We go for about a year, and then he enters a plea, and just a little.
No, he, in about a year is when he filed a motion to remove counsel.
Okay, and then how much longer do we go before?
And then that was another, so that was October of 2015 that he filed the motion to remove counsel, and then May of 2016 is when he entered the plea.
So we're coming up on a little over a year and a half.
Correct.
Okay, and then he enters a plea, and just over 2 weeks later, he goes, King's X, I want to withdraw.
Correct.
And so in that timeline, I know we have the argument there's got to be finality, that there's all these reasons we don't allow a defendant to withdraw a plea, but I'm not seeing it here. If he wants to go back and be subject to the death penalty, what's been the prejudice to the state for 17 days here out of a couple of years?
Well, the burden's not on the state. The burden is on the defendant to show good cause. And in the court's opinion, the same court that accepted the plea, that good cause wasn't shown. During the course of the plea hearing, as the district court noted, the defendant had every opportunity to halt those proceedings and to stop and tell the court, no, this isn't what I want to do. Instead, the defendant forged ahead and he assured the court, yes, this is the plea I want to enter. Yes, I'm doing it as a product of my own volition. Now, the defendant's claim that the court failed to take into consideration the fact that he had previously been dissatisfied with counsel is belied by the record before this court. During the plea hearing, the court specifically engaged in a discussion with the defendant that was driven by the fact that the defendant had previously been dissatisfied, and the court clarified, I just want to make sure that your plea is not adversely impacted by the fact of this prior dissatisfaction. And the defendant assured him that it was not. The court recounted that exchange in issuing its ruling here and simply found that it did not rise to the level of compelling evidence of coercion, which was the defendant's primary complaint in this case. Now, the defendant wants to point out and wants to focus on the fact that counsel was talking about the fact that you don't have hope if you go to trial, or you don't have a chance if you go to trial. First of all, defendant is claiming that those statements were uttered at the very outset of the time that his case was charged. Well, there was no plea offer on the table at that point. The plea offer did not emerge until many, many months later. We also have to look at the context in which those statements might have been uttered. The defendant is wanting to put those statements in isolation, but we also have to look at testimony from the defendant at the plea withdrawal hearing, where he acknowledged that when counsel brought the discovery to him, he was refusing to go through it with him, and that on multiple times he refused to meet with them. On record volume 11, page 19, in response to discussing the evidence, he says, when I first came to jail, counsel brought the laptop and a disk of evidence in, and I didn't listen to it. Now, the record will also reflect, and I was scavenging for the precise page, where he acknowledges that he refused to meet with them on several occasions. Mr. Rudy also testifies that oftentimes they would go to meet with the defendant and he would refuse to discuss the evidence. He wanted to talk about his girlfriend or his mom not coming to see him, or he would refuse to come up and meet with them because he was in choir practice. Now, could it be that in trying to drive home to the defendant the importance of reviewing that evidence with them, that this is a death case and this is the strength of the evidence that the state's case or that the state is prepared to present against you, and that's why we need to focus on the strength of this case. With respect to the mother coming to visit, the mother came to visit 15 months prior to the time that this plea was entered, and at that time it was also done, as counsel testified, in an effort to drive home to the defendant the importance of meeting with the state for the purposes of removing death from the table as a possible sentencing option. So when opposing counsel says that defense counsel testified, we were never going to trial, we weren't subjecting this child to trial or this defendant to trial. No. When you look at the record in this case, what counsel repeatedly said was, we are not subjecting him to death. That was their focus from the outset. We want to get death off the table, and we will proceed from there. What a fair review of the totality of the record shows here was that counsel met with the defendant approximately 60 different times. They amassed copious amounts of information in mitigation, and the district court acknowledged that it had personal knowledge of that because it had signed off on many orders in order to acquire information for mitigation. They brought discovery to him to review on multiple occasions. They simply wouldn't allow him to keep it in his cell. They shared discussions with him regarding the strength of the state's evidence and what possible lines of defense might be open to him. And they discussed the pros and cons of proceeding to trial or opting to enter a plea. The district court reviewed all of that evidence and determined that while the defendant may have had misgivings about the plea he opted to enter, those misgivings did not translate into coercion. And there is substantial competent evidence to support the district court's conclusion that the defendant was not entitled to relief on the motion that he had filed.
What about, this is a death penalty case, and at least in our experience with death penalty cases, multitudes of motions are filed right at the outset. And here, no motion was filed during the entire pendency of this case. Doesn't that go to Mr. Edwards' impression that trial was off the table? I mean, no motions filed in a year and a half?
Well, and that would be speculation. There was
I understand it's speculation,
sure.
but doesn't that, can't we, what do we read into that?
Well, I think it's dangerous to read too much into that. He had counsel appointed to him for the purposes of the evidentiary hearing here, and there was nothing proposed as to what motions could have or should have been filed. I think what we need to look at here is the totality of the evidence that was actually before the court that reflects that they were actually preparing for trial based on the amount of mitigation evidence that was presented, that they had, in fact, gone to that next step in case they were to proceed to trial, and that they were making every effort to communicate with the defendant. It may possibly be that the fact that the defendant was refusing to communicate with them somehow hindered their ability to file different motions.
Let me follow up on that, because when I prepared for this, I remember going through the transcript of the plea hearing, withdrawal hearing, and I remembered lots of discussion about the incidents at the jail. Didn't remember anything about counsel's notion of it being in front of the court that the counsel hadn't done anything. Okay, so I was going, but it's a long transcript and I can't find anything here.
Sure.
So first question is, do you recall that topic coming up in the transcript of the hearing?
Could you be a little bit more specific?
The idea that counsel didn't file anything, didn't do anything.
There, as far as from the defendant?
Yes.
I believe he did, and if you could give me just a second. I don't see it either, but I believe if it was not a statement made by the defendant, it was a comment that was made by Mr. Siebert, who was appointed to represent him during the hearing.
Yeah,
I believe
I
he
can
did
go
make-
back and look
Yes,
more
but
deeply
I don't see it.
when I get back to the office. But the one thing that does come up easily here, looking at the record on appeal, is that the table of contents for the record on appeal doesn't show a lot of activity. I think there's a request for a deposition, but I'm not seeing many filings
No, there were not.
in this. Okay.
Yeah, it is. Yeah, I specifically recollect that there wasn't anything filed, but I think it's dangerous to speculate as to why something may not have been filed and to just automatically assume it's a lack of diligence on defense counsel's part. because there were a lot of wheels turning. There were things that were pursued, as the district court specifically stated, in issuing its ruling, that I know that investigation was taking place because I signed off on orders to acquire information for mitigation. So there was that piece stated by the district court. But as far as any questioning to Mr. Rudy or Mr. Smart as to why anything specific regarding statements to law enforcement or anything of that nature, nothing of that was ever fleshed out during the course of the hearing, so we don't have any context or explanation as to why, and I think it's dangerous to speculate as to why on this record.
The other question I had, and I know I can match it up when I
Sure.
get back, but just in case you know, the presiding judge at the plea hearing,
Yes,
is that the same judge that heard the motion to withdraw?
yes.
Okay.
If there are no further questions, the state would respectfully request that the decision of the district court be affirmed.
Any more questions? Thank you, counsel.
Before I forget, I believe that the judge was also the same, Justice Biles, as the one that heard the hearing on firing the attorneys. It's the same judge that was at all the big deal hearings that were in this case.
Well, I saw in the record there was a motion to keep the same judge assigned, but I didn't match that up with when those different
Right.
things were filed.
Right, and in fact, the fact that the judge is the same all the 3 times, I think actually supports Mr. Edwards' argument, which is that judge knew the history of what Mr. Edwards' concerns were, and I think that the record I would not describe the plea hearing as thorough or Mr. Edwards being agreeable and assuring the court and things like that. That plea hearing, when you look at it, Mr. Edwards starts out yes, no, or yeah, no, nodding his head, and then tries to tell the judge, well, I guess, I'm not really okay with my attorneys. They had to take a break, and then after that, the answers continue with yeah, no, nodding. He doesn't even try anymore to talk to the judge about it. And one thing that strikes me here is that the state, when it comes to Mr. Edwards' plea hearing, he is truthful and agreeable and is assuring the court that this is what he wants to do. But all the other times, he's antisocial and just the kind of guy who would kill 2 people. And so when it benefits the state, apparently Mr. Edwards is truthful, but when it supports Mr. Edwards' contention, then he's antisocial and disagreeable and disrespectful. But anyway, the other thing I just want to address a couple other points that the state made. I am not saying that his counsel was not working really hard. I'm not saying that they told him he could have a trial. What I'm saying is that when you look at the overall context of how there were no motions filed, how infrequently they went to court, just the history of what happened here, that all of that supports Mr. Edwards' testimony that I was pressured to enter a plea. That was the way it was going to be. And in fact, Mr. Smart even testified at the motion withdrawal plea hearing that at the time that they entered Mr. Edwards' plea, they weren't ready for trial. They would have been able to get ready, but they weren't. And so when you look at the overall picture, we believe that the evidence supports not just Mr. Edwards' testimony, but the other evidence supports that he was in fact, what's the district court's words? Beaten down by his attorneys. And that is why he entered his plea in this case.
Counsel,
Yes.
at the time of the entry of the plea, was there a trial setting?
There was.
And how long off in the future was it?
Well, what had happened was the plea was on May 9th, and his
Okay.
next trial setting was June 6th.
Okay.
And before that, his prelim had been continued 4 times before he waived. And then his trial had been continued 4 times before he entered his plea. And interestingly, the standard here is good cause, which his attorney argued at the plea withdrawal hearing is the same standard you use to continue cases or hearings. And so there are in fact, all these continuances in his case. So that is the context, but there was another trial setting in about a month.
Thank you.
So if there are no other questions, we would ask this court, we understand what he is asking for and how that might feel, but Mr. Edwards is asking this court to in fact find that he was coerced into making his plea and that the district court erred in not allowing him to withdraw that pre-sentencing. Thank you.
Counsel, a kind of a vague reference was made earlier in these arguments about a credibility determination made by the court about your client's testimony. We did not get into the specifics, but my question is, if the judge found your client incredible on that particular piece of evidence, does that then flow into determinations elsewhere that the trial court made? Or are you saying that was just, it can be surgically excised and removed and we can proceed with your arguments?
You would have to surgically excise it because the other things that the court found were, well, I guess he wasn't coerced because he didn't tell me that he was. The court made other determinations that Mr. Edwards was credible on that other day, and that, so I think you'd have to excise it because of the other determinations the court had to make to even reach the decision that it did. I hope that made sense, but right, just because you are found to be incredible in this one part doesn't mean that the court is going to has to discount everything you say. And in fact, I think they can't if they're going to try and support the ruling that they made.
Thank you, counsel. Do we have any further questions? See none. We thank you both for your arguments this morning.
You.
Court will take this matter under advisement.